after the Delhi rape case, there is an immense expectation that we will see a change of laws that will make Delhi safer for women. But those fighting this on the ground know just how tough the battle is against entrenched belief systems, which are jolted only after every tragic incident. One of the first pivotal movements for those fighting for a change in rape laws was the legal battle over a 17-year-old tribal woman, Mathura, who was raped by 2 constables inside a police station in Maharashtra's Chandrapur district in 1972. Her trial over the next 2 years would reveal in its fullest all the deep-rooted biases in society, especially on women's sexuality. In acquitting the policeman, the Sessions Court held that Mathura was habituated to sexual intercourse, that her consent was voluntary, that she was a shocking liar and had cried rape to appear virtuous to the crowds outside, which included her lover, when actually she had enjoyed the sexual encounter. The Bombay High Court reversed the judgment and sentenced the constables. The court held that since the police were strangers to Mathura, it was unlikely that she would make any overtures or invite the accused to satisfy her sexual desires. But in an appeal in 1978, the Supreme Court acquitted the policeman, saying that Mathura's medical reports show no injuries, which indicate that the alleged intercourse was a peaceful affair. In all 3 courts, Mathura's character, her sexuality, was central to arguments on both sides. The Supreme Court judgment led to immense outrage, galvanized a public campaign to reform the rape law, which had been largely untouched since it was first enacted in 1860, when the Indian Penal Code was framed.
And it was such a travesty of justice that I felt very pained.
Upendra Bakshi, an eminent law professor, was one of 4 academics to draft an open letter to the Chief Justice of India, questioning the judgment.
Supreme Court, lo and behold, held in its wisdom that since there were no marks of resistance on her body, Mathura can be said to have consented to this sexual exchange or intercourse. So I decided to draft an open letter. The newspaper editors were worried about contempt of court, so for 6 months they did not carry the open letter. It's only when Dawn in Karachi published the full text that they say, why don't we get a copy of the letter?
The activism post-Mathura's landmark judgment led to a new rape law, the Criminal Amendment Act of 1983, which made some strong shifts. It reversed the standard tenet of innocent until guilty in cases of custodial rape. Punishment for rape was enhanced to 7 to 10 years. And a victim's testimony was to be given paramount weightage. More lobbying for change finally led to amending the Evidence Act in 2003 to ensure that cross-examinations could not bring up the past sexual history of the victim. But the euphoria over the new rape law diminished in the face of many loopholes. For one, rape continued to be defined as penetration of the vagina by the penis, which meant that hundreds of cases of serious sexual assault were not covered. Take Dhapubai's case, a Dalit woman from Tonk, Rajasthan. She was gang raped by a group of upper caste men more than 15 years ago. She had hot iron rods thrust into her vagina by several men. Her nipples were bitten and anal sex was forced on her. But the attack could not be called a gang rape legally, as the prosecution could not prove penovaginal rape despite penetration by the rods. Members of Parliament even refused to criminalize the rape of minors in the marriage. An account of those parliamentary debates are found in the book by Professor Gitanjali Ganguly. Here are some examples from across the political spectrum. Congress MP Sri Daga said, "The concept of rape within marriage is new. It is against our culture. In our country, in some parts, girls develop early. Even if they are young, their bodies are ready for sex." This is what L.K. Advani had to say. Reprehensible though child marriage is, it surely cannot be put in the same category as rape. We therefore favor an unqualified exception, saying that sexual intercourse by a man with his own wife is not rape. Even today, women activists are lobbying hard to revise the pending rape bill to ensure marital rape is criminalized. While it's easy to target the minds of the political class, tackling social biases, stereotypes in the legal systems is far trickier. It's not easy being critical of the judiciary, yet crucial, since those pronouncements become law and set legal precedents. Mrinal Satish analysed 800 Supreme Court and High Court judgments on rape post the Mathura case as part of his thesis and found that the biases, the stereotypes about a woman's sexuality, once part of a trial process, now seem to have moved to the sentencing. So while the issue of a woman's past sexual history has been fought off as part of evidence during the trial, it has crept back to affect the sentencing process.
India's #1 news app just got even better. Download NDTV's new app. Fully optimized for retina display. Full screen view. Faster response time. And Sudoku. NDTV's new iPad app. Download now.